So in case of Indian Contract Act 1872, we have started with the concept called as contract of indemnity. Contract of indemnity. Sir, in case of contract of indemnity, what is the meaning of indemnity? Sir, indemnity is nothing but to make good the loss. To make good the loss.
Compensate the loss.
Or it is also called as compensate the loss. Compensate the loss. So that is a normal meaning of indemnity. So the contract of indemnity discussed under section 124 of Indian Contract Act. What is the definition of contract of indemnity, sir? So listen, what is the definition of contract of indemnity? Sir, one person make a promise to the other person. Promise to other person. One person make a promise to other person. What promise, sir? To compensate the
Replace the
loss.
loss.
To compensate the loss. So one person make a promise to the other person to compensate the loss. Okay, sir. This loss arises. So how this loss arises, sir? This loss arises due to
Conduct of promise.
conduct of promisor himself, or due to conduct of third party. This is the definition we are studied in the last class. So what is contract of indemnity, sir? Contract of indemnity is a contract in which one person make a promise to the other party to compensate the loss arises due to conduct of the promisor himself or any other third party. This is the definition as per Contract Act section 124. So out of this, in case of contract of indemnity, there is a two parties. One is said the person who made the promise. No, this person is called as what is called indemnifier. That person is called as indemnifier. So for whom the promise is made, this person is called as indemnity holder. Indemnity holder. He is also called as indemnified. Indemnified. This is the basic introduction we are already learned in the last class. What is contract of indemnity? According to the section 124, contract of indemnity is a contract in which one person make a promise to the other person to compensate the loss arises due to conduct of the promisor himself and due to any other third party. In case of contract of indemnity, there is a two parties. One is indemnifier, another one is indemnity holder or indemnified. Who is indemnifier? The person who make a promise to compensate the loss. That person is called as indemnifier. Who is indemnity holder? For whom the loss is compensated, that person is called as indemnity holder or indemnified. This is the concept of indemnity. Everyone is clear now, sir. So now I will ask one question, then you can answer it. So listen, what happened? Sir, here Ram is there. Ram. One fine day, what happened? Ram is walking on the road. He walking on the road. The moment when he walking on the road, what happens, sir? He find out one thing. Suppose he find out a tablet on the road. A tablet. Not tablet, it's nothing but tablet is nothing but it's electronic device. Okay, sir. He walking on the road, he find out a tablet on the road. Then what happens? Ram becomes what happens, sir? Ram is the finder of lost goods. Same example we already discussed in the last class. He is a finder of lost goods. Then what is the duty of finder of lost goods? He can inquire for true owner. He can advertise for true owner. He can find out the true owner, and the true owner is found. Then he return the tablet to the true owner. That is the duty of finder of lost goods. Sir, he can give an advertisement, newspaper advertisement is given. Yes, newspaper advertisement given. I find out the tablet on the road. Any person who is the owner, please can approach and they can take it over tablet. Like that, he can give a newspaper advertisement. What happened? One of the person, Ravi is there. Ravi. So Ravi approached to the Ram. Arey Ram, I am be the owner of that particular tablet. Please provide a tablet to me. So in this scenario, what we have studied, sir, in this scenario, Sir Ram delivered the tablet to the Ravi. In future, Ram came to know that Ravi is not a true owner or a real owner, then Ram incurred loss. That is the reason why what happened, the Ram sir, the moment when he hand over the tablet to the Ravi, he can obtain a indemnity bond from the Ravi. Are Ravi, no problem. I will deliver your tablet to you. You are be the owner. No, I will deliver your tablet to you. But one indemnity bond is required for me, for me from your end. Why? Because sir, tomorrow other person came, he submitted all the proofs, he is become the true owner, then I incurred loss, I am liable to pay that money to the true owner. Then what I mean to say here, you will give an indemnity bond. What is indemnity bond, sir? Here we give an indemnity bond. What is the indemnity bond? Sir, Ravi said, make a promise to the Ram. Are Ram, tension mat karna. If any loss arises to you because of my conduct, because of any third party conduct, आपको loss हुआ तो no problem. You are incurred any loss, I will replace the loss. I will compensate the loss. Like that, Ravi make a promise to the Ram, then Ram delivered a tablet to the Ravi. Clear, sir? Sir, okay. Tablet is delivered. Sir, tomorrow, sir, after 3 days or 4 days, sir, here Lakshman will come. Lakshman approach Ram. Are Ram, I am be the owner of the tablet. Please give a tablet to me. Please give a tablet to me. I am the real owner. These are the documents. These are the bill. This is the picture of tablet. I am the real owner. Please, why you are delivered to Ravi? Please give a laptop. Please give a tablet to me. Like that, the Lakshman is demanding. Then obviously, who is liable? Ram is liable to pay that much amount. Why? Because tablet Ram के पास tablet नहीं है sir. Tablet is not there. Already tablet is delivered to the Ravi. Then how he can compensate the Ravi sir? Then whatever the cost of the tablet is there, no, that cost he can deliver to Lakshman. Obviously, sir, suppose Ram is not interested to pay that cost. Then Lakshman went to the court, file a case against Ram. Are Ram sir, he is doing this type of nonsense. Because of this, I incurred loss. Please give me my tablet to me, like that. Lakshman went to the court, file a case against Ram. Then what happens, sir? The Ram is liable not only the cost of the tablet. Ram is liable for the expenses, for court expenses also. The legal expenses also, the Ram is liable. And I say here Ram is liable for cost, Ram is liable for expenses, legal expenses. And also, sir, otherwise, no, sir, cost. Sir, he is compromised with the Lakshman. Are Lakshman, I am not able to pay that much money. We will compromise. We will settle. So what is the cost? Are 10,000 rupees the cost, sir? Are I will pay only 7,000 rupees. Please settle them this dispute now. Like that, the Ram enter into a contract with the Lakshman and they can settle the amount and they can settle with 8,000 or 9,000 or 7,000. Now the Ram can pay how much amount, sir? Settlement amount, compromised amount. And here in this example, Ram can pay a cost or Ram can pay expenses for legal charges. Ram can pay either settlement or compromise amount. So whatever the amount of loss incurred by the Ram, then Ram can recover from whom, sir? In this particular example, Ram can recover from Ravi or not? Why? Because already Ram obtained indemnity bond from Ravi. That is the reason why the Ravi is liable to pay to Ram. Ram has a right to receive. There is a 3 types of expenditures. One, Ram can recover cost of the damage amount. What is Ram can recover the damages, and Ram can recover the expenses for the suit, cost of the suit, and Ram can recover compromised amount from the particular party. Clear, sir? So in this particular example, sir, in this particular example, who is indemnifier? Who is indemnifier? So who is indemnifier and who is indemnity holder? So who is indemnifier and who is indemnity holder? So who is indemnifier, sir? Here Ravi is the indemnifier. So who is indemnity holder, sir? For whom the loss is compensated, that person is called as Ram. Then what are the rights of indemnity holder? What are the rights? Then he can recover from the indemnifier or not? So what are the rights of indemnity holder? What are the rights? So what are the rights, sir? There is a three rights to the indemnity holder. Sir, what are the rights? Right to claim for damages. Yes, sir, right to claim for damages. And also, sir, right to claim for cost of the suit. Right to claim for cost of the suit. Yes, you can file a case, cost of the suit, and right to claim for compromised amount. Claim for compromised amount. Compromised amount. So these are the three rights available to the indemnity holder according to the contract of indemnity. Clear, sir? Indemnity holder has a right. Why? Because of indemnifier, I incurred loss. Because of him is I incurred the cost of that particular tablet that's damaged, or cost of the suit. He went to the court, file a case against me, then I incur legal expenses. I can recover the legal expenses from the indemnifier, and also, sir, claim for compromised amount. Why? Because I am not pay the entire amount, so there is settlement and compromise between the indemnifier and indemnity holder, and they can incur the compromised amount, that much amount he can recover. This is the second part in the contract of indemnity, the rights of indemnity holder. There is a three rights: claim for damages, claim for cost of the suit, and claim for compromised amount. This is nothing but section 125, the rights of indemnity holder. So contract of indemnity consists of only two sections, 124 and 125. What is 124? What is definition of contract of indemnity? What is 125? Rights of indemnity holder. This is all about contract of indemnity. Clear, sir? What is contract of indemnity and what are the rights of indemnity holder? Everyone is clear? Now, sir, listen. Go through with that. So listen. So contract of indemnity. So this is a definition. Contract of indemnity. So contract of indemnity definition. A contract of indemnity is a contract in which one person make a promise to compensate the loss arises due to conduct of the promisor himself and due to the conduct of any other third party. There is a two parties, indemnifier and indemnity holder. Then next is section 125, rights of indemnity holder. What are the rights of indemnity holder, sir? There is a three rights of indemnity holder. What are the rights? What are the rights of indemnity holder, sir? Three rights of indemnity holder. What are the three rights, sir? One is right to claim for damages. Okay, so right to claim for damage. Second one is right to claim for cost of the suit.
Cost of suit.
Cost of suit. And another one is, what is the right, sir? Right is nothing. Right to right. Compromised
amount.
Compromised amount. These are the right to claim for damages, right to claim for cost of the suit, and right to claim for compromised amount. These are the three rights available to the indemnity holder. Everyone is clear, sir? Everyone is clear? Having any doubt related to that? Everyone is clear or having any doubt? Tell me, sir. Everyone is clear? Any doubt related to that? Okay. Now, sir. Then I can ask one question. We can answer it. Okay, so I can ask one question. You can answer it. Listen. Sir, Arjun is there. Arjun. Sir, Arjun is a resident. Resident is a resident. Resident in Goa. Okay, so Arjun is there. Arjun is there. He's a resident of Goa. Okay, so resident of Goa. So he is residing at Goa, but his house, sir, his house nearby beach. This is the beach, Goa beach. Okay, sir. Nearby beach is residing. Arjun recently purchased a car also. Okay, sir. Recently purchased the car. Yes, Arjun recently purchased the car. So whenever in India, sir, whenever you can purchase the car, you can obtain the insurance on the car or not. Obvious, it's a mandatory. So you can, whenever you can purchase a motor vehicle, insurance is mandatory in India. Then you can purchase the car. At the time of purchase, what happens, sir? He obtain insurance on that particular car also. Okay. What happens, sir? One fine day, what happened one fine day? There is a tsunami. Tsunami is there. Tsunami, the big tsunami. So what happens, sir? Because of that tsunami, what happens, sir? This tsunami, because of tsunami, only car is washed out. Car is washed out. Car is washed out. Tsunami, I mean, sir, a car is washed out of. So in this scenario, now insurance company is liable for that loss or not? That is my question. See, you obtain the insurance on that particular car. Okay, sir. Then because of tsunami, what happened, sir? Because of tsunami, what happened? Car is washed out, car is damaged. Then insurance company is liable for compensation or not? That is my question.
No, sir.
Not or not, sir. Listen. So what is contract of indemnity? Sorry. So what is contract of indemnity? ये क्या है सर? Contract of indemnity क्या है सर? Simple reason. Sir, any loss, so loss arises, sir, due to promisor himself, or due to third party. So in case of contract of indemnity, in the year contract of insurance की बात है. In case of insurance, what happens, sir? Insurance company make a promise. What we have studied, so contract of insurance is a contract of indemnity, sir. Once you can check it out. Sir, here the losses arises because of this situation. Losses arises because of insurance company. Loss arises to you. Bolo ji, because of insurance company losses arises to you? No, obviously no. Sir, because of third party, any third party losses arises to you? No. Sir, losses arises because of promisor, losses is because of any third party, ये भी called contract of indemnity. But in this example, losses arises because of natural calamity. How it is called as contract of indemnity? Indemnity का definition में that point is not included. Loss arises because of myself, loss arises because of third party, then only I will pay the damage to you, I will compensate your loss. इसमें damages arises to you because of myself, because of third party. It's a natural calamity. How I can replace? Insurance company is not liable to replace the money. Yes, insurance company is not liable. Why? Because that is not a contract of indemnity. Indemnity definition, what is definition? Losses arises because of promisor himself, losses arises because of any third party, then only the party, the indemnifier, compensate the loss. But इसमें sir, losses arises by natural calamity, that is not a contract of indemnity, the insurance company is not liable. Yes, obviously that is correct. But what happened in this scenario? The party said Arjun, what is Arjun? Okay, sir, went to the court, filed a case against insurance company. Then he argued in the court of law, so natural calamity is nothing but it's an act of God. God is a person, he is a third party, then the losses arises because of third party, then insurance company is liable. Like that, he is argued in the court of law, he convinced the judge and the court gave a judgment. Yes, it's an act of God. Act of God is nothing but it's an act done by a God. God is nothing but third party. So the contract of insurance is also a contract of indemnity. As per definition, contract of insurance is not a contract of indemnity. Why? Because It is not loss arises because of third party. So this is one of the famous case law in India. Based on this case law, so many movies are also there in Telugu, Gopala Gopala, in Hindi. Oh my God. Okay, so these are the two movies are framed based on the with the famous judgment in India. The famous judgments. Okay, sir. Like that, because of the judgment, what happens, sir? The contract of insurance is also a contract of indemnity. What I mean to say here, generally, as per definition, contract of indemnity, contract of insurance is not a contract of indemnity. As per judicial judgment, the contract of insurance is a contract of indemnity. That is the reason why contract of indemnity definition is not an exhaustive definition. Exhaustive means complete definition. Why? Because here insurance definition में नहीं है, but it is a contract of indemnity. How it is called as a? That is the reason why contract of indemnity definition, it's not an exhaustive. Exhaustive means complete. It's not a complete definition. Now, because of the judicial judgment, contract of insurance is also be a contract of indemnity. Clear? This is all about contract of indemnity and what are the rules related to the contract of indemnity. Okay, sir. So life insurance, sir. Most of the people say life insurance. The insurance may, sir, insurance may. What is the loss arises to you? What is indemnity? Any loss arises to you because of my conduct, I will pay the loss. No. What is the loss arises to you because of contract of insurance? Life insurance. Life insurance में आपका loss क्या है, sir? What is a loss? Any loss arises to you because of my conduct or third party conduct after death, then there is nothing but insurance is a contract of indemnity. The insurance company can pay total policy amount to you. Okay, so okay, no problem. The contract life insurance is also a contract of indemnity. Whenever the party dies, then they can replace the loss. Yes, replace the loss. Then they can replace the loss, but life is not possible to replace. That is the reason why they can pay the amount, the policy amount to the policy holder. Okay, so it's a contract of indemnity. What is that? I will replace the loss. So replace my loss, life insurance, my life is how you can replace the life. It is possible, not possible. That is the reason why they can pay the insurance policy amount. Okay, sir. This is all about what is contract of indemnity. So this is all about. So now we are discussed about section. What are the sections we are discussed? So listen. Right. Wait. So what is the section, sir? Here we are discussed about section 124 and section 125. Two sections are completed. 124 is a definition and 125 rights of indemnity holder. Definition में we are discussed, sir, life insurance contracts or the contract of. Oh yeah, it's not why. In ICA material, life insurance is not a contract of indemnity. Why it is such simple? Simple part. What is that? Sir, contract of indemnity replace the loss. Life insurance may we can replace the loss, replace the life. How is it possible? That is not possible. That is the reason why that is not an indemnity. But it is having the nature of indemnity. Sir, indemnity means replace the loss, sir. Life insurance may how it is replace the life, it is not possible. That is the reason why that is not a life insurance is not a contract of indemnity there. But contract of insurance, other than life insurance is there, no, then that is a contract of indemnity. But any loss arises to third party, no problem. It's an act of God also. That is a contract of indemnity based on the judicial judgments. Everyone is clear about this discussion? Yes, by giving money, replace the life is not possible. No, compensate the loss. Okay, so everyone is clear up to this discussion. Any doubts? Section 124 definition, 125 rights of indemnity holder. Clear, sir? Everyone is clear. Shall I move forward? Okay, okay, sir. Next. Next to concept, contract of indemnity is completed, sir. Next to concept, contract of what is the next concept is called as a contract of guarantee. Contract of guarantee. And contract of guarantee is also called as contract of surety also. ये भी same है. Guarantee or surety both are same. So listen, contract of guarantee and contract of surety. What is this? What is exactly means? So listen carefully. So here, X is a party. So X can approach a bank. Simple example: approach a bank, SBI bank or whatever it may be the bank. X can approach the bank for a loan. So इसमें सर whenever any person approach the bank for a loan, bank required. अरे आपके पास securities है यार. If you are having any security, keeping securities as a security, and I will provide a loan. आपके पास land है, building है, gold है, whatever it may be the situations, you can keep those securities as a security and obtain a loan. Except sir मुझे पास securities नहीं है. I am not having any security with myself. If I have the securities, I can sell and I can do the business. Why can I approach you? Then okay, no problem, X, no problem. We will provide a loan. Whatever, how much amount you are required? 10 lakhs amount I require, sir. No problem. Still, we are ready to provide a loan. But what you will do, you will get a guarantee. You will get a surety from a financially sound person. Then what happens, sir? X, one of the financially sound person, Ambani के पास गए. Ambani, मुकेश अंबानी के पास गए. Ambani साहब, so some guarantees required. Yes. Then you can provide a guarantee to me. Then in this scenario, what happens? An Ambani make a promise to the bank. What promise, sir? What promise made by the Ambani, sir? Sir, what is the promise made by the bank? Promise to the bank promise. Arey banker, tension mat karna. No problem, banker. You will provide a loan of 10 lakhs rupees to X. Okay, so you will pay. Sir, if we fail you to pay, I will pay. I will discharge. Sir, perform the promise of X. No problem. I will perform the promise of X. Perform the promise of X or discharge the liability of X. Discharge the liability. Discharge the liability of X. So like that, X means Ambani make a promise to the bank. What promise, sir? Are no problem, banker. You will pay 10 lakhs rupees to X. He failed you to pay. I will pay. I will perform X promise, or I will discharge the liability of X. Like that, he make a promise to the banker. Okay, sir. When I can perform, when I can discharge the liability of, sir, in the event of default of X. Default of X. X is defaulted, then I will pay, I will perform, I will discharge. Like that, Ambani make a promise. Based on Ambani promise, bank provide a 10 lakhs rupees to the X. Clear, sir? So this is called as contract. This is called as contract of guarantee or contract of surety. What is contract of guarantee? What is contract of surety? Contract of guarantee is a contract in which one person, Ambani sir, one person make a promise to perform the promise or to discharge the liability of third party in the event of his default. This is a definition as per section 126 of Indian Contract Act. What is the definition, sir? One party make a promise. What promise, sir? To perform the promise of person or to discharge the liability of third party in the event of his default. Ye called as contract of guarantee or contract of surety according to section 126. So इसमें sir contract of guarantee or surety में how many parties are there, sir? There is a 3 parties. 1, party number 2 and party number 3. ये 3 parties are. So this party, the person who obtain a loan, who is that person is called as principal debtor. ये called as principal debtor. The person who provide a loan, that person is called as creditor. The person who give a guarantee or surety, that person is called as guarantor or surety. So like that, in case of contract of guarantee, there is a three parties. One is principal debtor, another one is creditor, another one is guarantor or surety. Clear, sir? Sir, in this scenario, sir, loan is obtained for 10 lakhs. That should be repayable after 1 year. Sir, 1 year completed. 1 year complete होने के बाद, who is liable to pay, sir? Who is liable to pay? So who is liable to pay? X is liable to pay. X pay the money, no problem. A is not liable. Ambani is not liable. Sir, X failed, then only Ambani is liable. Attention here, initially who is liable, sir? Principal debtor is liable. Principal debtor failure to pay, then only surety is liable. That is the reason why, in case of contract of guarantee and contract of surety, may principal debtor liability is a primary liability. Primary liability. He is liable. First person is liable. Sir, the surety liability is what type of liability? Sir, surety liability is a secondary liability. So this is the concept of contract of surety and contract of guarantee. Contract of guarantee or contract of surety is a contract in which one person make a promise to discharge the liability of third party or to perform the promise of third party in the event of his default. Okay, sir. Sir, here, what is the difference between the indemnity and guarantee, sir? Indemnity may you make a promise and to compensate the loss to you. You are incurred any loss, I will compensate it. That is difference in main point in indemnity. But here guarantee may surety may, what is the difference, sir? I will make a promise, but what promise? I cannot compensate the loss to you. Okay, sir. He fail you to pay, then I will pay. Or he fail you to perform, then I will perform. Okay, sir. This is nothing but contract of guarantee or contract of surety. In case of contract of guarantee and contract of surety, there is a three parties. One is principal debtor, another one is creditor and surety. Okay, sir. There is a three parties, and also, sir, and also in case of contract of guarantee, there is a three contracts also. Wait. So three contracts. Listen carefully. So principal debtor is there, creditor is there, and surety is there. Sir, here what is that, sir? There is a three contracts in the contract of surety. One is contract between the principal debtor and creditor. This is contract number one. So one is contract between the creditor and surety. Contract number two. So one is the agreement between the principal debtor and surety. So this is nothing but contract and agreement number three. Sir, here, sir, this is agreement number one, agreement contract number two, contract number three. These are three contracts are there, three agreements are there. That is the reason why it is called as tripartite agreement. Tripartite agreement. Okay, sir, listen carefully. Sir, here, sir, what is that? So, in case of contract of guarantee, there is a contract of indemnity also. How, sir? What is where contract of indemnity is there in contract of guarantee? Sir, between principal debtor and surety. So listen, between principal debtor and surety, there is a implied contract of indemnity. Implied contract of indemnity. What is this, sir? Sir, why surety give a surety to you, sir? What is the benefit to the surety? You make a promise to the surety, or a surety, you will provide a surety to me. Any loss arises to you because of my conduct, because of creditor conduct, any loss arises to you, no problem. Surety, I will replace your loss. Like that, such a type of trust you are given to the surety, then only surety give a surety to you. Otherwise, surety cannot give any surety. So I will provide a surety to you, sir. So tomorrow you are failure to pay, then I incur loss. And you are failure to pay, I am liable to pay. Then how can I recover such loss, sir? I get indemnity bond from you. Or you make a promise to me. What promise? If any loss arises because of myself, because of third party conduct, I will replace the loss. Like that, principal debtor make a promise to the surety. This is the contract of indemnity. This is the contract of indemnity between these two people. He is the indemnifier. He is the indemnity holder. Indemnity holder. Like that, in case of contract of guarantee, there is a contract of indemnity between principal debtor and surety also. So after obtaining the contract of surety, the contract after obtaining indemnity bond from principal debtor, then only surety make a promise to the creditor, or a creditor loan. He should give a loan to principal debtor. Principal debtor fails, then I will pay. I will pay. Sir, indemnity may any losses arises. Here not, sir. No problem. He fail you to pay, then I will pay the money. He fails to perform, I will perform the contract. Like that, he make a promise. Like that, he make a promise to the other party. Okay, sir. Like that, this is nothing but in case of contract of indemnity, contract of guarantee, there is a three contracts. One is contract number one between the principal debtor and creditor. Contract number two, surety and creditor. Contract number three, principal debtor and surety. So this is called as contract of indemnity. Okay, sir. In case of principal debtor and creditor, one. In case of surety and creditor, this is the contract of surety. This is a normal contract, debtor and creditor contract. Like that, there is a three contracts in case of contract of indemnity. There is a three contracts. Okay, so listen. Clear, sir? There is a three contracts: principal debtor, creditor, and surety. This is one. This is one. This is one. There is a three contracts. Okay, na, sir? There is a three contracts. Okay, sir, clear? So listen. Sir, here, sir, whenever you are entering into any contract, contract in the sense, what is the meaning of contract, sir? Contract in the sense, agreement which is enforceable by law. So enforceable by law means section 10 conditions are satisfied. One of the section 10 condition is consideration. Okay, so consideration is one of the essential element. Without consideration, there is no consideration, no contract. The same things we are studied under foundation level. So here, sir, there is a three contracts. Sir, you said that there is a three contracts in contract of indemnity, sir. Coming to contract number one. What is the benefit to the principal debtor? What is the consideration to principal debtor? What is the consideration to principal debtor? Loan amount is the consideration. So what is the consideration to creditor, sir? Loan interest amount. You repay the loan along with interest not. That is a consideration to creditor. Sir, both the parties gets the consideration. Consideration is there. All section 10 conditions are satisfied. Then this is a valid contract. Yes. So coming to contract number 3. What is the benefit to principal debtor? Loan is the benefit to the principal debtor. What is the benefit to the surety, sir? Contra indemnity bond. Indemnity bond is a benefit to the surety. Here also consideration is there to both the parties. Then this is also a valid contract. So coming to contract number 2, sir. What is the benefit to creditor? Sir, interest amount is a benefit to the creditor. But what is the benefit to surety from creditor? What is the benefit to surety here? Whenever surety provided surety to the creditor, what is the benefit to surety from creditor end? Sir, I am giving surety to you, sir. What is the benefit from your to me? What is the consideration? What is
Giving
the
loan to
consideration,
principal
sir?
debtor.
Sir, here there is no consideration to the surety. So that is the biggest problem in case of contract of surety. In case of contract of surety, there is no consideration. So even though there is no consideration, contract of surety is a valid contract. So that is a speciality, sir. Why it is special contract? Even though section 10 condition is not satisfied, this is a valid contract. Contract of surety is a valid contract even though there is no consideration. Why? Because no consideration, no contract exception. One of the exception is nothing but contract of surety. Contract of surety is the one of the exception. So 3 contracts are there. Out of 3 contracts, first contract may consideration to both the parties. Second contract may be consideration to both the parties. But third contract, third contract may consideration. Second contract between the creditor and surety, there is no consideration to surety. Even though there is no consideration, the contract of surety is a valid contract. Okay, sir. There is no consideration in contract of surety. It's a tripartite agreement. It's a three contracts are there. Out of 3 contracts, one of the contract is contract of surety. In that contract of surety, there is a lack of consideration. Even though there is no consideration, contract of surety is a valid contract. Everyone is clear or not? Everyone is clear or not? Principal debtor, creditor, and surety. 3 parties are there. 3 parties and 3 agreements. This is one, sir, this is one. So why you are always writing dotted lines between principal debtor and surety? Why? Because this is an implied contract. What is implied contract, sir? Once you can approve the surety, you are entering into a contract with the surety, even though you are not mentioning any words in the agreement, any loss arises to surety, you can replace the loss. Nothing is mentioned in agreement, sir, no problem. Okay, sir, no problem. Okay, sir, there is no problem. But giving the loan to principal debtor by creditor may be the consideration, no, sir. Listen. So what is the generally contract of surety? There is no consideration. Okay, sir. But what lawmakers are says that, what is lawmakers are says that, sir, we are already studied about the consideration definition. Out of that, one of the essential element of consideration may move from promisee or any other person. No problem, sir. But what lawmakers clearly says that generally there is no consideration, but lawmakers add a additional point. What is the point, sir? What is the point, sir? Anything is benefit to the principal debtor. Anything is benefit to the principal debtor. Any activity done, any promises made, whatever it may be, anything is benefit to principal debtor, that is treated as a consideration to surety. That is a statement added in the law. Generally, there is no consideration, sir. Generally, there is no consideration. From the creditor to surety, there is no consideration. There is no consideration. Okay, sir. But what lawmakers clearly says that no problem. Anything is benefit to the principal debtor. Any activity done by to the principal debtor, any benefit received by the principal debtor, the benefit of principal debtor is nothing but consideration to surety. Okay, sir. Anything is done for the benefit of principal debtor. That is the reason why in ICA book there is a statement. So anything is done. Anything is done for benefit of principal debtor for PD. That is a valid consideration to contract. Valid consideration to contract of surety. So that is a statement. Generally, there is no consideration, but this is a statement. Why? Because we know the rule. Consideration may move from promisee or any other person. So promisee evolves now, sir. There is no need. You are obtaining the consideration from promisee. You are obtaining the consideration from more other than promisee also. That is the reason why we are discussed about the famous case law, the Chinnaya versus Ramaya case law and foundation. Consideration moving from mother, not from the uncle. Then that is a valid consideration. The same thing law clear that logic. By using that logic, lawmakers add one statement. There is nothing but anything is done for the benefit of principal debtor. That is a consideration to contract of surety. Generally, there is no consideration. There is a consideration to contract of surety. This is nothing but the definition of contract of surety. Section 126. Okay, so everyone is clear about the definition or not? So go through with the definitions here. A contract of guarantee is a contract. One person make a promise to perform the promise or to discharge the liability of third person. That is called as contract of guarantee. In contract of guarantee, there is a 3 parties: principal debtor, creditor, and surety. 3 parties. Okay, sir. Out of the principal debtor is a primary liability party. Yes, obviously. Surety is a what, sir? Surety is nothing but secondary liability party. Principal debtor failed, then only surety is liable. Principal debtor will pay the money, surety is not liable. So there is a 3 contracts in the contract of guarantee. Out of that, one of the contract of surety between the creditor and surety. Generally, there is no consideration, but anything is done for the benefit of the principal debtor. There is a consideration to the contract of surety. And also, sir, in case of contract of surety, one more important point in case of contract of surety, the implied contract of indemnity between principal debtor and surety is there. This is the definition of section 126 related to the contract of guarantee, contract of surety. What are the parties? How many contracts? What is the position of consideration? So another important point, sir. So principal debtor is liable for 1 lakh rupees. Principal debtor is liable for 1 lakh rupees. So listen. So principal debtor is liable to pay money to creditor or not? So principal debtor is liable for 1 lakh rupees. Surety is liable for how much amount, sir? 1 lakh rupees only. Principal debtor is liable for 50,000 rupees. Surety is liable for 50,000 rupees. Sir, principal debtor is liable how much amount? That much amount only surety is liable. To the what extent principal debtor is liable, to that extent only surety is liable. So such liability is called as coextensive liability. Coextensive liability. Coextensive liability. What is coextensive liability, sir? Liability is same as principal debtor. Principal debtor is liable, then surety is liable. Principal debtor is not liable, surety is not liable. What extent principal debtor is liable? To that extent surety is liable, then that is called as coextensive liability. Clear, sir? This is a concept related to the contract of guarantee introduction. That is today's session. Everyone is clear about today's session or not? Tell me, sir, you are having any doubt? Tell me.